Hello there, my dear friends. I am very happy to be back with you. I have been a little loaded since the pandemic, handling almost all the subjects in the College of Law of the University of Manila, mostly by handling the sessions on Zoom. Well, I am to share with you my suggested answer to the commercial law questions in the November 2022 bar exams. And I went through the details of the uh, questions, and there are about five or six modules that were taken from commercial law. Obviously, corporation was included, banking, transportation, insurance, intellectual property, and electronic commerce was included in the questions. By way of the number of occurrences, the 2022 bar examination had five questions on corporation law, and we'll go through that. No? And then there was one in banking, specifically on the issue of the secrecy of bank deposits and the anti-money laundering act. In transportation, there were two questions, very interesting. In insurance, the questions that were raised were fundamental but very important for us to understand insurance. Intellectual property has a latest slant. We will touch on the issue of the first to register or first to file versus the first to use under the Intellectual Property Code. And on electronic commerce, the question was asked on whether there is such a thing as cyber libel when people make comments in the internet. And so, without much ado, we now go to the five questions on corporation. The first question concerning corporation was question number five. And the subject matter has something to do with the nationalized industry in the Philippines. And the question is, how do you now reckon with the 60% Filipino ownership insofar as the total outstanding capital stock is concerned? The question runs like this. Fripp Company is engaged in a nationalized activity requiring at least 60% Filipino ownership. Its outstanding capital stock consists of 1 million shares broken down into 400,000 non-voting preferred shares and the 600 voting common shares, out of which 20,000 are treasury shares. The question, how many shares of the corporation must be owned by Filipinos? Explain briefly. Our suggested answer, capital refers to shares with voting rights as well as with full beneficial ownership. The right to vote in the election of directors coupled with full beneficial ownership of stocks is effective control of a corporation. The Filipinos must own 60% of the total shares outstanding of 588,000 out of the 1 million shares, determined as follows. Insofar as the preferred shares, which are normally non-voting, are concerned, that's about 400,000. You get 60% of that, and you have 240,000 shares, which should be Filipino. Take note here that the non-voting preferred shares is essentially just for corporate management purposes. But for purposes of determining the nationality of the corporation requiring it to be 60% Filipino, even the preferred non-voting shares would have to have 60% Filipino. So far as the common shares are concerned, which is 600,000, there is 20,000 of treasury shares which do not represent part of the outstanding capital stock. And so the voting common shares would only be 600,000 minus the 20,000 treasury shares. That would give you 580,000 shares of common stock. And this 580,000 would require 60% Filipino ownership, which is equivalent to 348,000. So of the total capital stock of 1 million, where you have something like 980,000 as outstanding, you need to generate 240,000 of the preferred non-voting shares as Filipinos. And of the 580,000, you need 348,000. That is the total of 588,000 out of the 1 million that should be total shares owned by Filipinos. It is very interesting that this was one of my tips. Nahulaan ko ito. It is pointer number 4 on page 4 of my tips to my bar candidates. Unfortunately, I did not have the opportunity to upload those notes because I was running out of time. This particular answer is consistent with Section 11, Article 12 of the 1987 Constitution, and was the subject matter of the cases of Gamboa versus Teves in October 2012 and repeated in the case of Roy versus PLDT in April of 2017. Moving now to the next question on corporation, which is problem number 6. Problem number 6 has something to do with the director's conflict of interest and what would be his liability for disloyalty. Bar question. Yuingo Gi, a director of BTS Corporation PH, both substantial shares of its major supplier, Hy-B Inc. When Hy-B Inc.'s contracts were taken up by the BTS Corporation PH board, Yuingi not only voted for their approval, but influenced other directors to do so. Later, the Hy-B Inc. contracts turned out to be disadvantageous to BTS Corporation PH and caused it substantial losses. Discuss the actions that may be pursued against Yuingi under the revised Corporation Code. Explain briefly. BTS Corporation shall file a civil action because Yuingi acquired personal and pecuniary or monetary interests in conflict with his duty as director when he bought substantial shares of supplier Hy-B. Yuingi is liable for all damages consisting of BTS losses. He must account and refund to BTS Corporation the profits which would have accrued to the corporation. And this is consistent with Section 31 and 34 of the revised Corporation Code and handled in 2017 in the case of IN and Schultz versus Tulet Prebon, a January 17, 2017 decision of the Supreme Court. The third question on corporation, which is problem number 7. Notice it's 5, 6, 7. No? It is one after the other. Problem number 7 deals with one of the fundamentals in corporation law, which is the piercing the veil of corporate entity. I would also look at this as the lifting of the corporate mosquito net. Because sometimes piercing the veil seems to be penetrating and therefore giving the impression that the corporation has been busted. And yet, when you look into the concept of piercing the veil, the corporate veil is only penetrated on a case-to-case basis to make anybody violating the separate entity theory be liable. So to my mind, I introduced in my lecture the so-called lifting of the corporate mosquito net. So that if you lift the mosquito net, you are not really affecting the corporation because you can always bring back the corporate mosquito net. But this question now in the 2022 bar examination has something to do with the advent of fraud in diverting invested funds. Let us take a look at the problem. Loco company, using a fraudulent scheme, was able to sell its shares to investors. The sale proceeds were then secretly diverted by Loco company to its wholly owned subsidiaries. Later, Loco company became insolvent and was placed under receivership. On behalf of the investor stockholders, the receiver demanded the inspection of the books and records of Loco company subsidiaries. Question A. Can Loco company's stockholders exercise, through the receiver, the right of inspection of the books and records of Loco company's subsidiaries? And second, is this a case of intra-corporate dispute? Explain briefly. Our answer on letter A. Loco company's stockholders can inspect the books and records of Loco subsidiaries. Piercing the veil of Loco and its subsidiaries can be done because of Loco's fraud in diverting the proceeds of their subscription. One of the reasons why you can pierce the veil of corporate fiction. On the second question, is this an intra-corporate dispute? The answer is yes. This is a case of intra-corporate dispute between investor stockholders versus Loco company. The diverting of the investment proceeds to Loco subsidiaries is a detrimental act of fraud by Loco's corporate officers, which is detrimental to the investing stockholders. This was a classic case in 2018 involving Osorio versus People and the interim rules of procedure governing intracorporate controversies under Republic Act 8799 is a relevant piece of legislation. The next question on corporation law deals with another fundamental concept. No? The first one we talked about as piercing the veil of corporate entity. The second one, to me, the only beautiful concept in corporation law is the so-called the trust fund doctrine and the priority of corporate debt. So, proceeding now to problem number 8 in the bar examination, it reads, Exit Corporation, no longer wanting to continue with its business, transferred to Entra Inc. under an asset purchase agreement all its properties and assets including goodwill. A creditor of Exit Corporation demanded from Entra Inc. the payment of Exit Corporation's debt for the reason that the transaction amounted to a merger and therefore the surviving corporation, Entra Inc., must assume the debts of the absorbed corporation, Exit Corporation. Is the creditor's demand tenable? Explain briefly. Answer is yes. The creditor's demand for Entra to pay Exit Corporation's debt is tenable. The trust fund doctrine demands that the property and other assets of a corporation be regarded as equity in trust to pay corporate creditors. The doctrine, meaning the trust fund doctrine, prohibits the corporation from distributing its capital assets and properties to its stockholders ahead of its corporate creditors. No distribution of assets among stockholders without paying the creditors first. Any disposition of corporate funds to prejudice the creditors is null and void. And this is decided in two very recent cases. One is not as new, but 2010 is relatively new in the case of Philip Turner versus Lorenzo Shipping in 2010. Another one is the case of Bowman Environmental Development versus the Court of Appeals in 1988 decision. So very fundamental. The assets of the corporation, including the capital stock, cannot be touched and given back to any person, especially any stockholder, when there are outstanding credit to creditors. The creditors will always have priority, and non-payment to them would be essentially fraud in violation of the trust fund doctrine. Number 11 is a question on financial rehabilitation and the need to distinguish suspension of payment versus insolvency. The problem reads, Kauf Corporation had suffered tremendous losses as a result of the COVID-19 pandemic and the resulting economic slump. From a calculation of its assets and liabilities, Kauf Corporation was technically insolvent, but management believed that it had a chance to survive if its rights to mineral properties could be exploited. Kauf Corporation has the right to several parcels of land containing nickel deposits. Nickel prices had gone up in the world market and nickel was in short supply. The creditors of Kauf Corporation are set to file suits for collection with application for writs of attachment. As the counsel for Kauf Corporation, what legal action would you take to avert the suits, and stave off insolvency and liquidation? Our suggested answer. As counsel, the legal action to avert suits and stave off insolvency and liquidation includes, number 1, voluntary rehabilitation proceedings. The debtor, and this is Kauf Corporation, can file with the regional trial court a petition for rehabilitation voluntarily or pre-negotiated. The court now issues the commencement order for the rehabilitation receiver to start the rehabilitation proceedings to include the review of all records and consolidate all legal proceedings. Number 3, the court issues a stay or suspension order to suspend all actions in court, to enforce claims or judgment, attachment or provisional remedies against the debtor, and prohibit the debtor from selling, encumbering, disposing any properties or paying liabilities outstanding when rehabilitation started. The second stage is the suspension of payment. The essence of financial rehabilitation is to try to revive the corporation from its monetary bankruptcy. In other words, it would appear like the cash inflows would not be sufficient to pay off the cash requirements to pay off the obligation. However, here, there is a component that the corporation may still explore the area of its nickel deposits. And so the rehabilitation receiver now will review the plans and probably would assist management develop a corporate strategy and obviously a financial projection to show that the expansion to the nickel business would allow sufficient cash flows that would accumulate to service the debts. Obviously, you cannot do this unless you freeze the cash flow. And so by the rehabilitation proceedings through court action, through, for example, the suspension order, all creditors, secured or not secured, will be told, hold on for a while. Let us take a look at how this particular corporation can somehow recover. And if we are convinced, then we support the program. Otherwise, when the evaluation of the creditor says it doesn't sound like the rehabilitation is possible, then that is when the corporation goes into liquidation. And obviously, if you are on the creditor side, you would have to probably suffer some uncollected exposure in the area of losses. No? So there is a little thing here. It says financial rehabilitation and insolvency under FRIA. That is the abbreviation of financial rehabilitation and insolvency, which was enacted in 2010. So those are the 5 questions that were asked in the November 2022 bar exams. This is the only thing that probably required a little more familiarization with financial rehabilitation. But every bar reviewer, somehow every law professor in mercantile law, commercial law, was anticipating that there will be a question in financial rehabilitation. Going back now to our main flow chart, no? We are now ready to go into, we're done with the 5 questions in corporation. We have now one problem in banking. Let's take a look at what the question in banking was all about. In banking, the question has something to do with the secrecy of bank deposits in relation to the anti-money laundering law. As you pretty well know, the fundamentals in banking says that when you open an account, that is supposed to be a sacred secret, and nobody can ask how much is the money that you have there. That is essentially the rule on secrecy, and we know that the greatest secrecy in banking is with the Swiss banks, you know. And they are even saying that a lot of money-making activities was there. Well, of course, they said mafia and things like this. But I was watching YouTube and Netflix just a few nights ago, and I overheard. I was surprised, you know, that apparently the wealth that Hitler's Nazi gang had accumulated had been deposited in the Swiss banks, and that should be earning a lot of interest somehow. And who would have the power and the knowledge to withdraw that for use is something that would be very interesting. In our case, the Marcos family is not denying that they have money. And they're saying that was not stolen from the government. And somehow along the line, I have been identified as a student leader in the 60s. In fact, I was in the blacklist of General Ver, having been mistaken as a follower of Joma Season's Kabataang Makabayan, when actually I was more of an anti-American in their participation in the Vietnam War and in their meddling on national affairs, including that of the Philippines. But I never accepted the hypothesis of the Kabataang Makabayan to overthrow this government and adopt a communist way of life. You know. Anyway, somewhere along the line, I got interested, of course, with my career in the field of business, corporate management, and financial management. And so banking became one of the areas where I'm interested in. And I found out the secrecy of bank deposits, except that when I was in law school, I immediately learned the original secrecy law had already 6 exceptions, which expanded to 13, which included an amendment or an enactment of a law that would allow the government to look into bank deposits that may be linked up to coup d'etat efforts. No? And later on, the area of anti-money laundering came because of the issue of money from the drug trade being uh, pirated out of the country. So let's go to the problem number 10 in the bar examination, and it reads like this. Bank teller Loris submitted a suspicious transaction report, STR, on Mary Chell, a politically exposed person, PEP, who, when asked about her deposit of 2 million pesos in cash, winked and replied, "Sikreto, te." The Anti-Money Laundering Council did not find probable cause which could support the belief that Marichel had committed an unlawful activity or was otherwise involved in money laundering. Marichel now wants to sue the bank and Loris for allegedly discriminating against her. Discuss whether or not Loris and the bank are liable. Our answer. Loris and the bank are not liable and in fact required under the anti-money laundering law to submit a suspicious transaction report. Loris reported a covered transaction amounting to 2 million, an amount much more than the threshold required limit for reporting of 500,000. So at any given day, when a bank depositor makes a deposit of 500,000, the anti-money laundering law requires the bank to make the suspicious transaction report. And so when the 2 million was being deposited by Marichel, the bank has no option except to report that to the Anti-Money Laundering Council. As a matter of fact, I have my impression is that with or without the bank reporting it, the system of monitoring by the Anti-Money Laundering Council is able to pick up any amounts of 500,000 deposited or more, and so that would automatically allow the anti-money laundering monitoring system to pick up this transaction direct from the banks. Okay. So the relevant law would be the Anti-Money Laundering Act, Republic Act 9194 and 9160, both in 2001. Then there is the revised implementing rules and regulation, and obviously it is interfacing with the secrecy of bank deposits, where anti-money laundering is an exception to the secrecy law. So this was the problem that was given in banking, and not really very difficult though, because the other area of secrecy is the issue of graft and corruption. So that is another area where the secrecy law will not allow you to be protected. I was lucky to have made the guess that this will come out under my tip number 11 in my list on page 8. If you would like to validate whether I am just claiming something that was not there. My candidates knew this and they were smiling when they saw this tip. It gives them a little feeling of confidence that they are a little ahead because the answer would be very easy for them. So we have already done two modules, 6 questions. We are now ready to go to another interesting topic, the concept of common carrier in transportation. In transportation, the concept of who is engaged in the business of common carrier, and this touches on a very current practice, the reservation system of Grab and the transport service. And there is another problem. Surprisingly, they probably did not make a fine-tuning of that problem. In labor law, a similar problem came out on whether there is a whether there is a what they call this employer-employee relationship between Grab and the drivers. And I will address that when I go to the suggested answers on labor. But in commercial law, this was their question. Kotse Corporation is an entity that provides pre-arranged transportation services for a fee using an online-enabled platform technology that connects passengers with drivers using their own vehicles. Question A. Is Kotse Corporation a common carrier? Explain briefly. And letter B. Are the drivers engaged in common carrier service? Explain briefly. Our suggested answer in problem letter A is that no, Kotse Corporation is not a common carrier. Kotse does not carry or transport passengers as its business. Kotse's pre-arranged service is simply to connect passengers and the driver who wishes to do the actual carrying or transporting of the passenger. That's a very fine line distinction. No? The real business model of Kotse is just to connect the passenger with the driver. And if you imagine, and if you have experience using this service, the driver may or may not respond to the invitation of Kotse here or Grab. It may simply ignore it, because it has other priorities. The driver has decided just to go to bed and sleep because it was raining. So here, the Kotse Corporation is not a common carrier because it is only connecting the passengers and the driver. And the decision is an independent decision on the driver to answer the invitation that is being passed on by Kotse Corporation from the passenger. Letter B. Are the drivers engaged in common carrier service? The answer is a driver with his vehicle registered with the Certificate of Public Convenience is the common carrier. When he actually carries or transports the passenger, it goes back to the fundamental question on who is a common carrier. Siya yung nagbubuhat, susunduin, dadalhin doon sa destination. And that is exactly what the driver is all about. And that is why he has a certificate of public convenience. The online-enabled platform technology which Kotse Corporation renders is simply a communication mechanism. I repeat, a communication mechanism which the common carrier vehicle owner pays for. No? It is no different na if you are a jeepney operator and you have yung mga, ano bang tawag natin doon, yung barker. Balik-balik ho, sakay na kayo, ganito. And that is the same thing that the the Kotse Corporation is doing. Except it is doing it rather than sigaw na sakay na po kayo, ginagamit niya yung technology. No? So yung barker, hindi yun ang common carrier. And if he makes use of technology, it doesn't convert him into a common carrier. I guess I am in total disagreement And I welcome our disagreement with some who already made an earlier comment. Meron mabibilis nag-submit ng comment nila na conclusion, no, is common carrier daw yung ano, yung tawag dito, yung barker. Kaya nga ako, laking sampalok, laking bustilyos, nasanay na ako yung mga tumatawag, balik-balik, lealtad, balik-balik, lealtad. And so, when this particular online enabling platform technology came into being, to my mind, when you make the barker, no, yung tagatawag, gumamit ng technology, it never changed the nature of his business, no, as a barker, yung tagatawag. Oo. And he is not the common carrier. Okay, so I would, ang biro nga nun, I would stick my balls on this fundamental concept. Natutuwa ako kasi ako'y pinanganak at lumaki doon sa kalye, doon sa Bustillos. At I have never been, even if I finally ended up having my own vehicles and my own cars, I have never gotten away from the situation where I am still part of the masa, the riding masa, and I can still identify that particular kind of job of a barker, no? Yung mga standby dyan. No? Nadagdagan na nga sila eh. When I started driving ngayon, pag nagpark ka sa tapat ng Mercury, nagpark ka sa tapat ng Shakey's, aba, meron expansion yung barker business, yung sige sir, atras. And they expect you to give them at least pagka 5 piso nga, masama pa ang mukha eh. Oo. Siguro dapat 10 pesos, 20 pesos. No? Pero ako dugong Ilocano, tama na yung 5 piso. Diba? Kung minsan hindi naman tumulong sa'yo, suddenly nagpark ka, wala doon. Mauutak Pag paalis ka na, biglang nakuha mo na yung buwelo. No? So, again, kung gumamit ng technology yon, it still does not change the fact na tinutulungan ka lang noon. He does not become a car owner or what we call this, a parking businessman. Hindi ganun. Okay. Continuing now, we have 2 problems on transportation. And one of the fundamental concepts in transportation is the exercise of extraordinary diligence. As we know, in the performance of one's obligation, the normal requirement is only the diligence of a good father of a family, which is ordinary diligence. It is in transportation that the law introduced the concept of extraordinary diligence. And so here, the subject matter would be the injury to a passenger. And there is a presumption of common carrier's fault or negligence when the passenger does not reach his destination safe, sound, and on time. Ganun kasimple ang problema sa transportation. And so let us go through the problem number 4 given in the bar examination. At around 4 p.m. of December 25, 2020, Christmas Day, Queenie and her child, Paeng, boarded a jeepney being operated by Emil and driven by Amor. Queenie was made to sit on an empty beer case at the edge of the rear exit of the jeepney, with their sleeping child on her lap. When they reached an uphill incline on the road, the jeepney slipped backwards. Queenie pushed both her feet against the stepboard to prevent herself and her child from being thrown out of the exit. But because the stepboard was wet, her left foot slipped and was crushed between the stepboard and the coconut tree, which halted the jeepney's backward motion. As a result, Queenie's leg was badly injured and had to be amputated. Queenie then sued Emil and Amor for breach of contract of carriage. Emil and Amor countered that the injuries Queenie sustained were due to her own fault, since Amor had instructed everyone not to panic. But Queenie nevertheless tried to disembark, which caused her foot to be crushed. If you were the judge, would you hold Emil and Amor solidarily liable? Explain briefly. I just wanted to make sure that the confusion between who is liable in a contract of breach of contract of carriage between the driver who is on the front line and the operator. Remember, the driver is only an employee. He's just doing his job. But the contract of carriage is with the operator, the owner of the vehicle, and the driver is only essentially his employee. So our suggested answer, I will hold Emil, the operator, liable for breach of contract of carriage. Mother Queenie and Child Paeng were passengers of Emil's common carrier who did not reach the destination safe and sound. When Queenie's leg was injured while she was a passenger in Emil's jeepney, the presumption of fault or negligence on Emil's part arose. He did not exercise the needed extraordinary diligence with said injury. The driver Amor is not liable for the contract breach because he is not part of the contract but merely an employee of Emil, the operator. The only qualification is if he was also guilty of criminal negligence, which is reckless imprudence resulting to physical injuries. But normally for the breach of contract, the civil aspect, the breach will be on the part of the operator. And simpleng-simple lang. Pagka hindi dumabot sa destination, safe and sound yung passenger, meron na kagad breach and therefore damages. This was actually a case that was decided in the case of Sanico versus Colipano, a 217 decision. Okay. So those were the two problems in the November 2022 bar examination on transportation and common carrier. Nangangalahati na tayo, no? Apat na lang na problem. We already handled 8, no? 5, 6, 7, 8. So let's now go to insurance. Very interesting problems in insurance. In insurance, one that was touched, which is problem number 1, pagbukas mo ito kaagad, is something to do with marine insurance and double insurance. And so we run now and say, Samson Manufacturing Inc. insured its own goods with Delilah Insurance for 2 million pesos. The same goods were insured by Alibaba Shipping Company with Assured Corporation for the same amount pursuant to its contract of carriage with Samson Manufacturing Inc. Both policies warranted that no other insurance exists, and in case another insurance exists, such would not void either policy, but in no case should the claim exceed the total amount of 2 million at the time of loss. Is this a case of double insurance? Explain briefly. Our answer in problem number 1, no, this is not double insurance. Double insurance exists where the same person is insured by several insurers separately in respect of the same subject and interest. Samson's interest is different from Alibaba's interest. Samson Manufacturing, as owner of the goods shipments, has an insurable interest different from Alibaba Shipping as the common carrier who can incur liability for failure to deliver Samson's goods. So, the insurable interest of Samson has something to do with the danger that the goods may be lost while it is in transit. So he can suffer as the owner of the goods, and he wants to be reimbursed when that particular incident should happen. On the other hand, Alibaba is the marine transport carrier, And if he therefore breaches his contract of carriage, then he will be liable to pay. You know, and so he has his own potential liability of having to incur an obligation to pay. However, there cannot be any double compensation here because if the ship were to go down and therefore the 2 million worth of cargo were to be lost, then Alibaba, as the common carrier, will be reimbursed under his marine cargo insurance to allow him to reimburse in turn si Samson Manufacturing. But that would now allow, therefore, the insurance company of Alibaba, no, nandito, si Assured Corporation, to be subrogated, into the right of the manufacturer, of the common carrier. No? So hindi magkakaroon ng double compensation. Sasabihin na nung for example nitong Delilah Insurance, you did not suffer any loss anymore because while I insured your cargo against the loss or damage, you did not really lose anything because you were already paid by the common carrier, who in turn got his money from his own insurance company. Again, very luckily, mga kaibigan, this was a tip number 19 on page 7 that I gave to my candidates. And this is not new because this was decided in the case of Giagonia versus Country Bankers Insurance of February 1995. When you talk about marine insurance and yung double insurance supposedly, dito lumalabas yung Giagonia case. No? At the same time, yung double insurance, no, pwedeng mag-double insurance ka basta walang double compensation. And the only time that double insurance becomes a basis for breach of contract is in the case of 5 insurance. Kasi the double insurance may lead into an over-insurance. But that is not the subject matter of this particular case. Okay. Let us now move to the second problem in insurance. And this is on life insurance on the issue of consent and the issue of concealment. No? Itinago yung kanyang pagkakasakit, and therefore this brings about the probability that the insurance company may cancel the insurance coverage. Okay. So let us go to problem number 2. No? Kanina yung problem number 1, nakita natin. Ito yung problem number 2. No? Moviel obtained a life insurance policy from X Insurance Corporation. Moviel underwent a medical examination and was certified as qualified to be insured. Unknown to X Insurance Corporation, Moviel had a mild stroke some years earlier. The insurance policy provided that any misrepresentation in the questionnaire filled up by Moviel for the issuance of the policy would render the policy null, void, and of no effect. Question A. If Moviel dies within the 2-year period from the time of issuance of the policy, will the beneficiaries of Moviel be entitled to claim the proceeds of life insurance policy? Explain briefly. And the second question, should Moviel die after the 2-year period, will your answer be the same? Explain briefly. Take note of the 2-year period being a significant component in life insurance concealment. The answer in letter A. No, Moviel's beneficiaries cannot claim the life insurance proceeds when he dies within the 2-year contestable period. The insurance company can contest the policy for concealment or misrepresentation when that particular concealment is discovered 2 years after the insurance was in effect. Or if there was a reinstatement of the policy, dahil naputol, hindi nagbayad, tapos ni-resume, the 2 years will be counted from the time of reinstatement. So, if the person dies within the 2-year period, mabibisto ngayon merong concealment, then the insurance company can now invoke to rescind the contract. Now, there is a very interesting question here because some law professors that I had, of course, when I was a law student, I never wanted to challenge the professor. Professor siya eh. Ngayon, nung ako yung naging professor na, tsaka ako na ngayon pinag-aaralan yung question ko. Because there is a colatilla in the insurance code that somehow mentions that the concealment is to be discovered somehow during the lifetime of the insured. So, kung 2 years yung concealment period, no? At lumampas yung 2 years, hindi na-discover yung concealment niya, hindi na pwedeng i-rescind ng insurance company. Ngayon, ang magandang question is, papaano? No? So, the insurance company has 2 years to discover. Okay. Let's say namatay siya sa kalagitnaan ng 2 years, 1 year, no? Namatay siya. Ang question is, who enjoys the benefit of the contestable period? Merong nagsasabi dati, and that was later on negated by more authorities on this subject matter, na kapag ka namatay siya within the 2-year period, siyempre madidiscover na ng insurance company dahil lalabas yung concealment niya may autopsy, mga ganun. So at that point, no, patay na siya, ang sinasabi ng mga ibang authors, hindi na pwedeng contestahin noong insurance company. My position, even when I was still a law student, and I continue to sustain that, when I finally became a law professor and the bar reviewer, is that the 2-year period belongs to the insurance company. So that kung namatay yan after 1 year, at siyempre, i-autopsy, ma-discover yun. Meron pala siyang cardiovascular problem. The insurance company can still invoke rescission of the contract out of concealment kahit napatay na. And I would submit that the insurance company will have to enjoy the full benefit of the 2-year period. Hindi kailangang matigil yung kanilang paghahanap ng concealment dahil namatay lang earlier than the 2 years. My position is, pagka namatay yun in less than 2 years, umaandar pa rin yung prerogative of the insurance company to now negate and contest that particular concealment. Okay? Now, question B. Should Mubiel die after 2 years? Ayun, 2 years na. Tapos tsaka namatay. The answer will be, my answer will not be the same. Mubiel's beneficiaries can claim the life insurance proceeds when he dies after 2 years, the incontestability period. The insurance company can no longer annul the insurance policy even when there was concealment or misrepresentation after the policy has been in effect after 2 years. In other words, the insurance company is given no more than 2 years to discover the concealment. When they do not discover the concealment within that 2-year period, tsaka namatay, then the prerogative of the insurance company to cancel the life insurance contract by reason of concealment is no longer legally available. Okay. And this was decided in the case of Manila Bankers Life Insurance versus Aban in 2013, no, bagong-bago. And then also earlier, the case of Tan versus Pilam Life Insurance in June 1989. So those were the 2 questions that were asked of insurance. Ayun, nakatapos na tayo ng 4 na modules, 2 problem na lang, and they are really nakakapuwing. No? But the more challenging one is intellectual property. Tingnan natin. In intellectual property, the problem runs this way. And it has something to do. Tandaan nyo, intellectual property, 3 yan, no? When you talk about inventions, formulas, you talk about patents, no? When you talk about literary or musical work, you talk about copyright. And when you talk about brand names, for example, SM, o BDO, o for example, UST, UE, no? Mga branch yan, no, ng mga eskwelahan, no? Or for example, Honda o Toyota, ano. These are all brand names, and from the point of view of intellectual property, they are labeled as trademark. Trademark. Ang pinaka-classic na naglaban dito sa trademark, yung beer ano natin, yung dalawang leading beer natin, yung San Miguel beer, tsaka yung kay Joe-Santos beer na beer, yung naglaban. Oo. Diyan niya lumabas yung dalawang tests, yung holistic test, saka yung the other one. No? Now, this problem had something to do with a very classic question on who is entitled to the trademark. Is it the one who is first to file, or is it the one who was first to use? And this is very interesting. Because traditionally, kung sino yung unang gumamit ng trademark, yun ang may karapatan. But in the latest reenactment of the intellectual property law, inabandon yung first to use, ginamit yung first to file. Kaya unahan kung paano magpa-file. But this particular case now introduces the very interesting question on, meron nang gumagamit dati. Tapos may nag-rehisto naman, no, na ginamit din. So what happens now? Okay, let us go through this particular problem, number 9. Sui Generis Corporation is a pharmaceutical company operating in the Philippines since 1999. One of its products is a drug called carbamazepine under the brand name Chenaps, which is an anticonvulsant used to control all types of seizure disorders of varied causes like epilepsy. Yung mga inaatake, nanginginig, no? Yan yung gamot para makontrol yung ganong yung nagkukumbulsyon, kaya anticonvulsant. Nati Pharma, also a pharmaceutical company in the Philippines, sells citicoline under the mark Chenaps. Magkatunog, ano? Ito Chenaps, ito rin Chenaps, which is indicated for the treatment of cerebrovascular disease or stroke. Ito naman yung mga na-atake. Okay. Chenaps was registered as a trademark by Nati Pharma with the Intellectual Property Office of the Philippines on September 24, 2017. No? Much later than the use of Chenaps by sui generis in 1999. Nauna sila, pero ito naman ang nagparehistro later ng 2017. On November 29, 2017, Nati Pharma filed with the Regional Trial Court, RTC, a complaint against sui generis for injunction, trademark infringement, damages and destruction with prayer for temporary restraining order and or preliminary injunction, alleging that sui generis Chenaps is confusingly similar to its registered trademark Chenaps, and the resulting likelihood of confusion is dangerous because the marks cover medical drugs intended for different types of illness. Ito, panlaban sa kumbulsyon, no? Nanginginig. Ito naman panglaban sa naninigas, no? Stroke. Sui generis, in its answer, countered that 1. It has been selling carbamazepine under the brand name Chenaps since 2004. 2. It was impossible for Nati Pharma not to have known the existence of Chenaps before the latter's registration of Chenaps, because Nati Pharma had promoted its products in the same publications where sui generis had advertised Chenaps. 3. Despite its knowledge of prior use by sui generis of Chenaps, Nati Pharma had fraudulently appropriated the Chenaps mark by registering the same with the IPO. And 4. As the prior user, sui generis is the owner of Chinaps, and the continued use by Nati Pharma of Chinaps will cause it grave and irreparable damage. Thus, sui generis prayed for the cancellation of the trademark registration of Nati Pharma's Chinaps. Ibababa ko ng konti yung picture ko muna. Okay. Question. As the RTC judge, will you enjoin sui generis from further using the mark Chinaps? Siya yung unang gumamit pero hindi siya nakarehistro. Explain. Letter B. Is sui generis prayer for cancellation? Nauna siya eh. Pinaka-cancel niya ngayon yung Nati Pharma's trademark that was already registered. Okay. Now, what is the answer to this particular question? Okay. Letter A. No, as the RTC judge, I will enjoin sui generis from further using the mark Chinaps. No, I will not enjoin. Hindi niya patitigil yung una, no, si sui generis. No? Sui generis, as a prior user in good faith, may continue to use its mark even after the registration of the mark by the first to file registrant in good faith as an exemption to the infringement. So ito, principle ito na ginagamit na sinasabi kung ikaw yung naunang gumamit at later on may naunang nag-file, yung naunang nag-file does not allow does not allow that particular later one to say, oy, tigil ka na. Kasi here it is saying that dahil ginamit mo na yon, nauna ka, no, meron kang karapatan na ituloy mo yung paggamit nun. Okay. Now, second, sui generis prayer for cancellation. Yun naman pinaka-cancel nung una na gumamit doon sa kinirehistro na later. Nati Pharma's trademark registration is not tenable. Nati Pharma is the first to file registrant in good faith to be entitled to trademark registration and ownership. This has codal provision section 147-1 and 159-1 of the Intellectual Property Code. As I was saying, mga kaibigan, this was a tip given by me, number 10 on page 8. And surprisingly, I have a case before the Intellectual Property Office. And it's very embarrassing. Pinag-aawayan namin ng mga fraternity branch ko. Dahil supposedly kami mas matatanda, kami yung nag-imbento nung pangalan na Beta Epsilon Sigma Fraternity, which is brilliant and excellent students. Beta Epsilon Sigma. Aba, merong mga sumusunod na generation. Dahil doon kami raw professional na, hindi na raw kami bumabalik sa UE, sa campus. Sa totoo daw, sa kanila raw yung fraternity. Sila raw talaga yung founder. Oo. Hindi raw kami. Talagang kapala ng mukha. No? Kaya, ayun, bakbakan kami ngayon. Mayayaman na rin sila eh. Mayaman sila, kami rin, hindi naman kami pobre, bakbakan. Sila, mayaman, pero hindi sila abogado, so nangyayari, they hire, hotshot lawyers from Makati to fight us. Kami naman, dalawa kaming very senior lawyers, yung isa si Attorney Eugene Mateo, who used to be the chairman of the Board of Accountancy, CPA lawyer. Na salutatorian din ng UE Law. Nagalit kasi kami, hindi naman kami talaga nagtayo lang ng fraternity na yan. We used to be neophytes, nagulpi rin kami at naging master kami ng original fraternity na Phi Beta Rho. Kaya lang, hindi exclusive honor society yun when it was formed. So when we were asking UE to recognize us as a duly accredited fraternity, sabi sa amin, hindi na raw magre-recognize ang fraternity na puro gulpihan. No? Gusto raw nila yung matitinong fraternity, exclusive honor society. Eh di yung ano namin, mga 30 kami, siguro mga 10 kami na honor student, hindi kami mare-recognize dahil nga there are some of our masters who were not honor students. Mabuti na lang yung mga hindi honor students, yung mga older generation na mga founders, eh naawa sila sa amin. Sabi niya, sige, mag-ano na kayo, tanggalin nyo na lang yung pangalan namin just for purposes of registration. Total, we will always be fraternity branch, right? Whether we are given official recognition or not. Sabi niya. Kaya lang sabi ko, Brad, hindi na natin mare-recycle yung ating pinasok na fraternity na Phi Beta Rho. Kaya ang maganda, Brother Joe, pwede ba ka akong mag-adapt tayo ng baby frat? At kami ka ako ng mga honor students, total, payag naman kayong tanggalin. Hindi na namin kayo tatanggalin yan. Mag-i-spin off lang tayo ng baby frat na pareho pa rin nun tayo, pero iyon ang ipapasok namin. That is how Beta Epsilon Sigma was formed. No? And it was recognized as baby frat. Di recruit na kami. Yan. Baka akalain nyo, after so many years, yung mga mas bata, siya na naman daw ang founder. You know, they came up with a lot of perjuries to present them. Total, di naman sila humarap sa amin, yung mga abogado. Eh, yung mga abogado, kaya magsinungaling at hindi naman nila alam kung ano yung totoo. You know, that's the reason why when I was doing my research, I found out ito palang si Senator Jubito Arsalonga, one of the bar top notchers of the 1944 bar, side by side with Senator Jose W. Jokno. Eh, si Jubito Salonga pala is one of the outstanding members ng Sigma Rho ng University of the Philippines College of Law. For some reason, nabasa ko, nag-resign pala yan sa Sigma Rho. Of course, ang Sigma Rho, nandiyan pa si Juan Ponce Enrile, at si Franklin Drilon. Oo, at yung namatay na si Edgar Angara. Tsaka yung isa pang kaibigan ko na naging presidente ng Integrated Bar. Katapat nila yung Upsilon Sigma Pi, tsaka yung Alpha Phi Beta ni Chief Justice Renato Puno. Pero nag-resign si Ramon, si Jubito Salonga. Binibiro ko yung mga old-timer brads namin. Hindi raw pala tayong founder Kasalanan natin Takot tayong mamatayan. Kaya yung mga palo ng paddle natin, medyo kontrolado. Dapat pala ako nilakasan natin, tsaka tinaas natin para sa bato ko sa ulo tumama. Para yung mga buisit na yan, hindi na siguro naging master. No? Ngayon, tayo pa ngayon na lumalabas na, first to use kami. Ini-invoke nila ngayon sila first to file. Kaya this problem in the bar exam became so interesting for me. And this is not easy. No? If you do not know intellectual property, it would not be easy for you. And so mga kaibigan, that would be the end of intellectual property. Isa lang ang binigay. So if we go back now, we're ending with our electronic commerce last problem in the bar. And this came out as problem number 12 on electronic commerce and the issue of original electronic contract. This really put me in a challenging situation and really took me a little while to research and figure out how I will face you with my suggested answer. So the problem runs, in a Facebook live stream, an author offered his books online for sale by asking interested viewers to type in mine in the chat box. A set of his books was sold to a social media influencer who later turned out to be a Joy reserver. The author made a screenshot of the social media influencer's mine message as proof of the acceptance of the offer. Thus, the screenshot of the message proved the perfection of the sale contract. Explained briefly. So, sabi niya, kung gusto mo mag-reserve, i-type mong mine. Pag na-type mo yung mine, ang position ng author is meron ng consummated contract of sale. Para may proof siya, kinuna niya, screen. Ang tanong ngayon is, pwede na ba yung screenshot na yon as evidence? Our answer, using electronic commerce. And this was a tip given to me that I gave, problem number 12, page 9. I said, no, the signature of the sales contract, the electronically typewritten mine, should appear in a printout of the data stored in a computer or similar device as an output readable by sight or other means shown to reflect the data accurately as an original. The original document rule requires the original as proof that its contents shows the sales contract was perfected. To make it simple, no? So yung tao, tinype niya doon, mine, no? Nandun sa screen. At syempre, babalik yun doon sa author. No? Ang sabi ng author, kung kinunan ko yung screenshot na nakatype na yung mine niya, no? Okay na ba yun? Ang sabi, hindi. Under electronic commerce, dapat yung input niya na mine, nakasave sa data bank mo. Tapos yung data bank mo, kaya mong i-print yun. Na nandun. Hindi yung screenshot, kundi merong paper na pwede ka i-print to show exactly what was the screen and you save that in your database. Yun ang sagot doon. Okay? And this is following the Section 4, original document and documentary evidence under Rule 130. And there are decisions here. MCC Industrial versus Sangyong, a 2007 decision. And then Electronic Commerce Act, Republic Act 8792. And then the rules on electronic evidence under Administrative Matter number 01-701 Supreme Court, July 17, 2001. And so mga kaibigan, that is my excitement in sharing with you what I thought would be the suggested answers to the questions on commercial law. As to whether the examiners will agree with me depends upon how they would appreciate these answers. I am a little hesitant to, without any solicitation to give this thing to them. But anyway, this YouTube is public, and if they should sound me out about wanting to have a copy of this, I am more than willing to give them a copy of this particular suggested answer. To my mind, the questions and answers to commercial law in the November 2022 are not bar questions that are wido-wido. They have foundation, and if you did review properly, then you would be able to have given the correct answers. With this mga kaibigan, nagpapasalamat ako sa inyo for allowing me to again be back with you. I am dedicating this to all the bar candidates who have sent me their responses. Ang dami dun sa mga slides na na-upload ko na. Naiiyak ako pagka may sumusulat sa akin, Dean, nandito ako sa Cagayan, wala akong pera, mahirap lang ako, hawak-hawak ko lang yung mga notes ko sa College of Law. Pero sa cellphone ko po, nakaka-login ako ng YouTube, pinapanood kita din. Pati yung mga kwento mo, natutuwa ako, nalilibang ako. Yan lang po ang ginamit ko para kumuha ng November 2022 back. Ganon din po ang mga feedback na nakatanggap ko magmula sa Surigao, magmula sa Bicol, magmula sa Iloilo at Bacolod, magmula po sa Zamboanga, Cagayan de Oro, doon po sa Davao, At dito po sa Metro Manila, nahihiyang aminin pero paminsan-minsan may naglalakas ng loob na nagsasabing din nanonood po kami. I never had this facility when I was a law student. The only technology I had at that time was Walkman. Ang dami kong tape ng Walkman, puro caudal. I never gave up listening to caudal. And I am very, very happy. 27 years na po akong abogado. And I never imagined to survive even law school. Because at the age of 35, I had already a cardiovascular problem. May bara na yung puso ko. Sabi ng cardiologist ko, if I go to law school, and I was 40 at the time I asked her permission, hindi raw po ako tatagal ng 4 na taon. Mamamatay daw po ako sa College of Law. Kaya po, tanong niya, Joe, bakit ba gusto mo maging abogado? Willing ka bang mamatay na hindi ka naman magiging abogado? I said, pangarap ko po yung bata pa po ako. Wala lang po kaming pera. Nag-asawa pa po ako pagkatapos ng aking accounting. Kaya kayod na po. Wala po. Kinalimutan ko na po maging abogado until may mga nakita akong mapanda pa sa akin, lumulusot sa bar. Kung ako po nag-aral kaagad, kaklase ko siguro yung naging presidente ng Pilipinas na nag-aral sa San Beda. Magkabatsa na kami ng 72. Meron ho kami pareho, mahilig ko kami pareho magmura. Pero ganun ho talaga Siya, hindi sumama ng graduation. Ako naman, kasama sa graduation, pero matanda na. And so, nanaginip po tayo mag-top sa bar. Sino pong hindi mananaginip? Talaga naman pong alam natin na meron tayong ilalabas, pero minsan masyadong matapang ang sagot mo na hindi nagustuhan ng examiner. But when I took my oath as a member of the Philippine Bar, I was holding on to a very old volume of the Civil Code, CODA, na binigay po sa akin ng aking father. Ginamit ko po nung ako'y kumuha ng CPA dahil merong commercial law sa CPA. Yung pong ginamit ko rin after so many years, almost 25 years, hawak-hawak ko pa rin. So when I took my oath as a member of the Philippine Bar, I was clutching to that civil code that my father gave me. And my father was no longer around. He could not wait for the day when I was 47 years old to become attorney at law. Pinakamaligaya ko po yun. Marami na po akong nakuhang mga honors, pero yung mapasumpa ka doon na member ka ng Philippine Bar, napaka saya po. Childhood dream. It was the fulfillment of all my boyish hopes and dreams. Quoting General Douglas MacArthur. Nandiyan na po halos lahat yung mga academic honors. Nandiyan na po lahat yung mga degrees at mga titles sa corporate world. Pero wala pa po itong mga salo. That is why 10 years after I became a lawyer and I was appointed Dean of the College of Law of the University of Manila to take over the retiring Dean Michael Moralde, an idol, somebody who also believed that I can be a good lawyer. Ako po yung sumusunod sa yapak niya na naging Dean ng College of Law. And another very illustrious lawyer appointed me for that. si President uh, de los Santos. Kaya po nung ako ay na-nominate ng 2012 as Associate Justice of Supreme Court, tama na po yun, nakasali tayo sa public interview. Biro mo, umabot pa sabi nung cardiologist ko, mamamatay daw ako sa College of Law. And yet, nandun ako, 2012. Hindi na bata, pero I am sure my credentials allowed me to be there. And again, in 2016, I think, nominee na naman. Kasabay ko si Justice Kagiwa. Noong una, kasabay ko si Justice Leonen. And I really felt so good nung sabi ni Justice Sandoval Gutierrez, Din Bisquera, why are you only applying now? Parang sinabing, matagal ka na dapat nandito, ba't ngayon ka lang? Sabi ko, na-late po tayo sa pagkuha ng law, pobre lang po tayo. Parang feeling nila sayang. And there were some members of the technical and medical staff of the Judicial and Bar Council, JBC, na bumulong sa akin. Sana din mag-isip sila na ma-appoint ka. Kami nagte-testing dito kaya alam namin kung sino yung deserving. Ma'am, tama na po doktora ito. Nakasali ako sa final race. Alam naman po namin na ang appointment mo sa Supreme Court, hindi naman po yan yung magaling pinag-uusapan. Magagaling mo lahat sila. Pero appointment po hindi po doon. Nasa Malacanang po tapos na. And so this to me, reaching out to you and sharing with you my love of the law by answering some of the bar questions is part of the joy of being alive as a member of the Philippine Bar and being called Attorney Joe-Santos, Balagtas, Bisquera. Nadagdagan pa po na Dean Bisquera. At kayo po, nagtsatsagang manood sa aking mga YouTube, nagtsatsaga sa aking mga kwento, nagtsatsaga kung ano man po ang kakayanin ko bilang kasama nyo na abogado. Maligaya po ako being with you. Pag nanonood pa kayo nito, one-on-one tayo. Kaibigan nyo po ito. Nagpapasalamat. And kapag matutulog na kayo at you make the sign of the cross, sama niya naman po si Dean Bisquera na kaibigan niyo na sana magpatuloy pa ang privilege na binigay sa kanya ni Lord para maging member ng pinakamagandang profesyon sa mankind, the field of law. Thank you very much, and I will see you. There are more subjects. Ready na halos yung criminal law. Ready na rin po yung labor law. Pinapalis ko na lang po yung civil law. May nauna yan yung isang batang abogado, bumanat kagad. Pinakinggan ko naman, tinitingnan ko kung yung may mga sagot siya na alanganin na meron nga, hindi kami pareho, and I will take my position there. And finally, yung procedural law. Mas gusto ko po yung tawag nilang procedural law kaysa remedial law. Kasi yung remedial law, remedyo, parang ine-emphasize yung arigluhan. Pero yung procedural law, yung sistema ang ine-emphasize. So I love they resurrected again the title procedural law under Justice Leonen, binalik na naman, tawag na naman remedial law. So marami pong salamat and I will see you soon. Thank you very much for being with me. Thank you.